So, hello everybody. We're back again for another webinar live stream, and happy to answer any questions that people may have regarding wills, writing a will, any terms they've seen in a will, any confusion about using our service, or questions about our service in general, what we do at Legal Wills. So I hope everybody had a great summer and back in the swing of things. Just some general news from us at Legal Wills. We have just celebrated our 25th anniversary of offering this service. So it was actually back in September 2001 that myself and my co-founder, Henry Raud, started the company based on an idea. And that idea was, it actually came from us going out after work one time, and somebody around the table said that they didn't have a will in place. And we went around the table. Nobody around the table had a will in place. And we were all adults with families, with jobs. And at that time, we said, well, there's a problem. That's a broken system, because we all knew that a will was important, but none of us had managed to get it to the top of our to-do list. And that was the seeds of an idea for providing a service that would remove those barriers to writing a will. So here we are 25 years later. We are still developing our service. We're still trying to make it better and better and better. We've developed it over those 25 years. We've now done somewhere in the region of about 500,000 wills. We're available in Canada, the US, the UK, and now in South Africa. In Canada, we're available in every province and territory. We are bilingual in every province and territory. And 25 years behind us, and we're looking forward to the next 25 years where we can continue to offer an affordable, convenient solution to writing your will. It is an important document. Dying without a will is never a plan. It's never, ever, ever a good idea to die without a will and leave people behind, your friends, loved ones, family, trying to deal with your estate when you don't have a will. So before we get into the questions, I am just going to say what I say up front every time. I am not a lawyer. I have worked for 25 years in the wills business. I've seen probably 10, 20, 30,000 questions come into our support desk over the years. I do know the kind of questions that people do ask about wills. I've seen the replies to all of those questions. I do still read every single question that comes into our support system as well. So those are questions either about wills in general or about the use of our service and what our service offers. We do, absolutely. We answer questions that people have, questions from people who are not our customers, people who have questions about their own will, getting a will, or a family member's will. My father, he has a will and we're trying to sort it out. They'll ask us questions. But the point is, I cannot give you legal advice. I cannot give you answers specific to an individual situation. There's a law against me providing legal advice. It's called the unauthorized practice of law. I'm not allowed to do it. Exactly where that line is drawn is an interesting one. My general feeling is that if the answer I give is readily available on a public forum, on the internet, then I'm more than happy to provide that answer. But if you need answers tailored to your own situation, then absolutely we recommend that you do speak to a legal professional, explain exactly what your situation is, and allow them to draw upon their legal knowledge, expertise, look at previous case law, and they'll be able to give you a proper legal answer to any question you have. But I'm more than happy to answer general questions. Okay, so with that, I am going to go into some questions. I do see some questions coming in on the chat. So let me take this first question that's come in on the chat. Do all wills have to go through probate? And I think it's first off, it's important to understand what probate is. So if you were to die and your executor, you name an executor in your will, and that executor's responsibility is to gather up all of your assets, secure your assets, and then make sure that they go to the beneficiaries that you've described in your will. So an executor, if they were to go to a bank with your will and say, this person died last week. I even have a death certificate. This person died. Here's their death certificate. And here's their will. And I'm named as the executor. So can I please take everything out of the bank account? And the bank, if they say, yeah, okay, it looks like, yeah, there's the will. It's signed and witnessed. That's cool. And the person's obviously died. You have the death certificate. You're named as the executor. Show me your ID. Okay, there's your driver's license. You're definitely the person they're describing as your executor. Here's all of the bank account. And then they go, great. 2 days later, somebody else shows up at the bank and says, hey, this person died last week. I'm the executor. Here's their will. They did have an older will, but this one they wrote after that one. This is their official last will and testament. This is the actual will. Can I please take all of the money out of the bank? And the bank looks at them and says, oh, we actually gave it to some other guy last week. He had gave us a will. We thought that was the will, but you're showing us another will that was written after that one. So the simple moral to this story is the bank can't validate or verify a will. They have no way of doing it. And we often hear from people who say, you know what, I went to the bank with the will and the bank said they wouldn't accept the will. They won't. They can't. There is an official process for firstly validating the will, making sure there's no challenges, making sure there's no other wills. We know, like, there's been celebrities. Aretha Franklin, she had like 5 wills scattered around her house. The process for saying this is the official last will and testament of this person, you are the executor, and the court is going to appoint you as the executor of this estate. That process is probate. The executor is then given a document called a grant of probate. And then that grant of probate is the document that executor then goes to the bank with and says, you know what, the court has officially recognized me as the executor, and I am now gathering up this person's assets. What they would then do is typically they would open a bank account for the estate and put all of those assets into the estate of John Doe. He died, and I'm gathering up the assets and I can now distribute them. So let's go back to this question. Do all wills have to go through probate? Well, actually not, right? If all of the assets are jointly held, so if the bank says, you know what, you're the executor, you're the spouse of the person who died, and you're the joint account holder, we can move everything into your name. That's a pretty low risk maneuver on our part. So we don't require the will to go through probate. It's important to note as well that an asset, an individual account, doesn't go through probate. Either the will goes through probate or the will does not. So the short answer is, if every asset is jointly held and every asset is going to be going to the joint asset holder, probably not. Likewise, if there was only like a few $1,000s in the account, probably wouldn't need to go through probate either. The only time a will would need to go through probate is if a bank says, no, it's too risky for us to give you the assets, the balance of this bank account. We want to see a grant of probate. And then in that situation, the will would have to go through probate. So there's 2 things about this. Firstly, what can you do to make sure that your will doesn't have to go through probate? Well, one of them is move everything into joint assets. So jointly held assets typically would not require the will to then go through probate. But I think there's a really important thing to think about here too. The other one is having named beneficiaries, right? So in a registered account in Canada and in bank accounts, some bank accounts in the US, you can actually name a beneficiary on that directly on the account, so it's not even covered by the will. So that's another strategy for making sure that the will wouldn't have to go through probate. But and actually, another way of doing it in the US, there's a thing called a living trust. You can put everything into a living trust, so it's not even a part of the will. It's not covered by the will. But I'm going to assume that a lot of people on this call are in Canada, and I think that we read a lot about probate and how to avoid it, and the scourge of probate. And it's not that big a deal. It really isn't that big a deal. Like some provinces, the cost of probate is really not that much. Like Quebec, I happened to look at it recently. It's $200. They're near enough. Alberta, they have a fixed fee, so it's not a percentage of the estate, and it ramps up. It's scaled a little bit, but if you had a $5 million estate, the cost of probate is $500, like 0.0001% of the estate. So probate doesn't necessarily have to be feared in the same way as I know that in the US, there's a lot of information about how to avoid probate. There is another point to this. One of them is probate can be time consuming. I get that. So you do have to wait for your place in the queue to actually get that grant of probate. So it can slow things down. But the actual financial burden on the estate in some cases isn't as big a deal as the cost of restructuring the estate to avoid it. Whew. Long answer, like to a 8-word question, but it comes up a lot, and so I just wanted to make sure that I explained it in its entirety. You know what? I was going to like have a theme for this whole session, and it was about executors. And we're getting a lot of questions about executors. So I do want to spend some time on this. Can you just name an executor in the will, or must you ask them first before you write them in? So absolutely, you do not have to ask your executor before you write them into the will. You can write them into the will, no problem. There's one big caveat here. They are perfectly entitled to say, I don't want to do it after you've died. Right? So after you've died and you've named that executor, and the executor, they say, hey, guess what, Joe? You've been named as Tim Houston's executor. And Joe said, I don't want to touch that. I'm busy. I have no interest in being the executor of that estate whatsoever. So we actually say it's a good idea to let the person know that they have been named the executor, because it is a task that they have to accept and be prepared to take on. If they say, no, I don't fancy it, then it will go to the person who's named as the backup. So if that person, they say unwilling or unable, if that first choice is unwilling or unable to serve as the executor, it's going to go to the backup. And if you haven't mentioned it to them either, they are perfectly entitled to say, I don't fancy it either. And then you're left with an estate and a will with no executor. And you hope that somebody can then step up and say, well, I'm prepared to do it. But this is a long, convoluted process, because then they have to be appointed by the courts to say, you know what, they're not named in the will, but this person's prepared to do it. It slows the whole process down. So the bottom line is no legal requirement to let them know, but practical requirement, absolutely. Please let them know. And with our service, when you step through our service, once you've named somebody as the executor, we actually have a button to say, do you want to let your executor know that you've named them? And we really do recommend that you click that button and let them know. And we don't just ping them and say, hey, this is a text message, just to let you know. We actually send them a guide, a step-by-step guide of their roles and responsibilities for the executor. That is available at Legal Wills as well. You can access the step-by-step guide. It's like, I think it's like a 10, 12 page step-by-step of what that executor is required to do at what stage of the proceedings. So some things have to be done immediately. So immediately, things like funeral, it has to be arranged. The executor is responsible for arranging the funeral with a funeral home, and you may get, and the reason being is right from the get-go, you may get some family dynamics there. And some people will say, you know what, Tim, he always said he didn't want to spend $20,000 on the funeral. He always said that. He always said that he would rather that $20,000 go to charity. And somebody else said that is not befitting of his legacy. We should be really going all out with the funeral. So immediately there's some family dynamics there. The executor's responsibility is to say, okay, I'm the executor. This is what we're going to do. He's left no other direction here, so I'm going to determine what we should be doing. That takes me to another point. So we do have a My Funeral service as part of our Legal Wills portfolio of services, and we really do recommend that you go into that and give some indication of how you want your funeral to be, because your family and loved ones are going to be grieving. They could potentially be vulnerable, emotionally fragile, and it's not a good time for them to be making big decisions around what the funeral the style and the cost of the funeral should be. So it doesn't hurt to put your funeral wishes together ahead of time. You can either store those with the will, or actually you can leave them online within your account. And maybe we'll have time for me to get into this idea of setting up a key holder as part of the service at Legal Wills. Yeah. Okay. There's one coming in. So I just wanted to say, in answer to that question about letting them know, please, if you have questions about what the executor has to do, is yes, arrange for the funeral. The other thing that they really need to do is get an idea of what your assets are, secure your assets, gather them, and set up a bank account. But there's also a lot of bureaucratic stuff that they need to do. They need to file tax returns with CRA, a lot of forms to be filled in, notifications for different benefits potentially. So it's worth taking just a look at the checklist that we do provide, so that you can choose the right person as your executor. Very common for people to name their spouse as the executor, and that does make sense in many cases, because a lot of the assets may be flowing directly to that person. An executor can totally be the main beneficiary. There's no conflict there. Very common to name the main beneficiary as the executor. In many cases, that makes sense. In some cases, it doesn't. If you die when you're 90 and your spouse is 93, they're probably not going to be able to do all of the work of the executor. No offense to very able and sharp 93-year-olds out there, but it's a lot of work. Conversely, if you die when you're 30 and your spouse is 30 years old, your death probably came as a bit of a shock to them. You've left a bit of a hole in their life. The last thing they want to be doing at that point is back and forth with CRA. So sometimes it makes sense to name a spouse, and sometimes it makes sense to name another really capable friend or family member. Another part of that, and I will get to some more questions, but a lot of the questions that are coming in are somewhat related to this, is about compensation, and how an executor gets compensated. And that changes and it varies in different jurisdictions. For example, in the UK, if it's a friend or family member, typically they wouldn't receive compensation for doing that. In Canada, even with a friend or family member, the individual provinces set out their scales for what an executor should receive in compensation. And that's a percentage of the estate based on the size and complexity of the estate, which is set, kind of calibrated by the courts at the outset of the estate administration. Certainly a friend and family member can say, you know what, I'll pass on that. I don't want to take that, but they are entitled to it because it's a lot of work. It is work. Their expenses are covered, so they're not going to be out of pocket. That's covered by the assets in the estate. There's certainly another point we often get asked is, are they responsible for any debts? Absolutely not. They just have to gather the assets and they can pay for the expenses out of the estate. But they can also choose to receive compensation for doing the work. Certainly professional executors will do that. If you name a bank or a trust company, they are going to, or even a law firm, they are going to take a percentage and potentially even an hourly rate on top of that. So that can be expensive, particularly if you had a house in downtown Toronto, Vancouver, and that house could be worth a lot of money. Transfer the ownership of that house for 50% of the value of that house. That seems like a lot of compensation for not that much work. So paying $50,000 to change the title on a house is not actually great value for money. So two points to that is that if you do name a friend or family member as your executor, they don't have to know everything. The will would typically give them the authority to hire as and when they need it. So when they have to do that final tax return with CRA, they can hire an accountant to do that and pay for that out of the estate. Absolutely. So they can hire people as they need them without paying them a percentage of the estate. The last part of that is within the will, can you say, I want to specify exactly how much the executor is going to receive? We get that question a lot. And we don't allow it as part of our service. It's not a thing in our service. And there's a good reason for that. The will isn't going to come into effect today. It's going to come into effect, could potentially be 20 years down the road. And if you said, I want my friend Roger to be the executor and we're going to give him $500 for doing this work, by the time the will comes into effect, Roger might look at that and think, $500, that is not worth my time. It seemed like a lot of money 20 years ago, and it really isn't. And even if you put a percentage in there, a percentage of the estate, you don't know the value of your estate. You don't know the size of your estate. You don't know the complexity of the estate. So if, for example, the estate is wrapped up in a lot of litigation, there's creditors, there's accidental death lawsuits going on, there's a whole bunch of stuff that really adds to the complexity of the estate that you had no idea about. And you've said, my friend Roger is getting 1% of the estate. Well, Roger was really embroiled in a lot to get this done. And that is why we recommend that you really rely on the size and complexity calculation that comes from your jurisdiction rather than putting it in. You can put it in even using our service, but we recommend you not putting in a specific amount for that executor compensation. And let's go on the executor thing. If all the executors have died, what happens with the will? The will is perfectly valid. It's still a legal will, but you have nobody to carry out the instructions in the will. So what would happen is that you're going to hope that somebody's going to step forward. A friend or family member will step forward and say, I'm prepared to take on that role. And then they can be court appointed as the executor. If nobody does it and the executors have all died, or they all say no thank you and nobody else is prepared to do it, you are going to end up, the estate could be managed by the provincial public guardian and trustee. It's not an ideal situation. There is a government department who would do that. If you look up the public guardian and trustee of just about any province, they're not they don't come really highly recommended. I've never personally dealt with them. So I'm only saying this anecdotally from what I've heard from people. You're a file number. You're going to be in there. It's a government department. They're probably understaffed, overstretched. It's going to take a while. So, yeah, it's what this really speaks to is make sure your executors are young and healthy. Give them a chance. A lot of people name their parents as the executor. Not a great idea. Probably not the best thing to do, because they're going to be at least one generation older than you. So yeah, try and name somebody that you think has a decent chance of outliving you. The other important point to this, now I'm on a roll with it, is update your will. If your executor becomes incapacitated or hospitalized or some way unable or unwilling to serve, even your backup executor, and this happens a lot for people who have written their will with a lawyer, that their backup executors taken ill, moves to Australia, something like that, and you don't bother to make the update in your will, please make sure that you update the will. If your executor, your first and second choice executors, are unable to serve. I want to go. I'm going to miss some. I'm not going to get to all these questions, and I'm really sorry. But I'm picking out these executive questions. Is it complicated to name two persons as co-executors? A lot of people want to do this. They have two adult children. They want to name the two children because they want to be fair. They want to give them both the equal responsibility. So people say, well, this is fine. What I'll do is I'll appoint them to act as co-executors, but they can act independently. And I'll put that in the will, like jointly and severally, they can act. In practice, that won't work because a bank, no matter what, is going to want both executors to sign on every form that they're dealing with. So what invariably happens in this situation is one of the executors renounces their role, and you can absolutely do that. There's a form for doing that, saying, I'm fine, I don't want to be involved, I'm going to renounce my role as the executor, let that other person do it alone. Naming co-executors, yes, it's complicated. It's never beneficial to do that. It will only slow things down. It can never speed things up. So you think you're trying to be fair. You're just going to cause a headache because they will both have to do everything together. Okay, I'm going to touch this one on this one because it's not. Oh, actually, I'm going to go. Sorry for that. I'm going to do that one as well, but this one's an executive one. Executive insurance. It's popular. There are services that provide it, and this is insurance in case the beneficiaries aren't happy, or they feel that there's some things that the executor did that were not in the best interests of the estate or of the beneficiaries. This can come about, and I'm not an expert in this area, but it can come about for things like investments. And then the executor goes to cash out the investments, and oh man, if they'd done it a week ago, those investments would have been worth 50 grand more. But they kind of stalled on it, and their stock market tanked, and now they've cashed out the investments, and then the beneficiaries are like, we said cash out the investments, and now look at it, you've cost us 50 grand because of your negligence or apathy about cashing them out. So there's things that can happen that can really upset the beneficiaries, and you can get executive insurance. Do I recommend it? It doesn't really matter whether I recommend it. I'm sure these companies would absolutely recommend it. I would recommend you did your due diligence and explored it. There may be situations where it makes more sense than other situations, but it's there, it's available. It's a good thing to bring up for this call because people who have been named executors may not know there is such a thing. There is. It can be popular and it can be can be worthwhile, but I'm not going to recommend one way or the other. I did put this one up and then put it down again, so I think it's only fair that I address it. In the event that our children don't have any children and they all pass away, how do we add my brother and my husband's brother as beneficiaries, half and half? You can absolutely do that within our service. Um, let's assume, for example, that, and I'm going to touch on this because it's an important one. So within our service, you're going to name a distribution plan, and that distribution plan, let's say I'm going to leave everything to my spouse. Simples. But if my spouse predeceases me, I'm going to leave everything to my children. And if the way it would work is, you say, well, what if you had no children? So and this is something that we do at legal wills, and people are like, are you kidding me? Like, if my wife and my children all predeceased me and I had no grandchildren, I don't care. It's going to be so miserable. Why do I have to contemplate all of these really awful situations? Well, it's just that we really want the will to have a permutation. Like, whatever permutation happens, the will has to work. You don't want to be left hanging with no instruction. So we do kind of have to cover all of these worst case scenarios. So in this situation, you can say, this is not a first choice plan. This is not a second choice plan. It's not even a third choice plan, because the third choice is it would go to my grandchildren. But if they don't have grandchildren, fourth level of planning, you can do that actually using our service. We allow you to click on none of the above, let me describe, and you can quite simply put in there, if my children have children of their own at the time of this will coming into effect, then I want it to go to their children. But if they don't have children of their own, then I want their share to be divided equally between my brother and my husband's brother. You can absolutely do that. So it's one of those scenarios, your brother and husband's brother probably shouldn't be going out spending their inheritance, because there's a good chance that they're not going to be receiving it. It's a unlikely permutation, but it's there, and you can absolutely do that using our service. You can click on none of the above and put as many levels of what if scenarios that you want to cover. With that, I'm just going to touch on this one here, and I have spoken about this previously about will registries. So on wills, I am familiar. It's a part, I believe, of Hull and Hull, I think, have developed it. So there's a will service provider who now have a will registry. So let's be clear here. So will register after you've died, your family has to find the will. And if you've written a will with a law firm, there's a good chance that your family have no idea which law firm you used, and they can't find the will. So in Canada, in BC, they have a will registry. You register the date that you wrote the will and where the will is stored. And that where the will is stored is likely to be, I've stored it with Jones, Smith and Doe LLC law firm. They have my will. So if the family go to look for it, they'll know, because the law firm's not going to know you've died. So you've got to tie those things together, the people who know you've died and the people who have your will. No other province in Canada has it. No US states have it, and the UK doesn't have it. So what's happened is that private companies have set up to try and fix this problem. They are not government endorsed, but it's a problem. I get it. It is a problem that people can't find wills that have been written by law firms. Now, using our service, if you've named your friend or family member as the executor and you let them know where the will is, it does fundamentally the same thing. As long as your executor can find the will, you're fine. You don't need to register your will with one of these companies. You're not registering with none of these companies. Are you registering the physical document? You are registering the date that it was written and where you have chosen to store it. And that could be as simple as my bedside table. So do we recommend a will registry? What I would say is I recommend that your executor can definitely access your will. They know where it is. They know that they are named as the executor and they have access to it. So don't put it under lock and key. Don't hide it. Don't put it in a bank safe deposit box where nobody else can access it. The executor needs to get it. If you've taken care of that and your executor can get access to it, a will registry, a private will registry, doesn't offer a tremendous amount of value over and above that. A will registry may say otherwise. They may, and maybe they could convince me otherwise. I personally can't see what value they add. I think On Wills is free to, and it's only for Ontario, by the way, On Wills, hence the name. I think it is free to register it. There is another one called the Canada Will Registry that is not free. It's free for people who use legal wills, but it's generally, I think, $40 to register. And it's also a charge to do a search as well. So your loved ones are going to pay $70, $100 to do a search and then to say, actually, we don't have a record of it. There's a company in the UK called Certainty. They do the exact same thing. So it doesn't give you anything over and above making sure that the executor has access to the will. We say, if you've named a friend or family member as the executor, put the will in a sealed envelope, give it to them and say, hi, Bob, as we discussed, you are named as the executor in my will. Can you please look after it? It's in this sealed envelope here. If anything were to happen to you, you have the will. That's all you need to do. So with that, I'm going to draw it to a close. There were questions I didn't get to. So what I do at this point is I'm more than happy for people to get in touch. If I did not address your question, and I apologize, I kind of stuck around the executor theme today. Please, by all means, get in touch with me, tim@legalwills.ca. I do absolutely answer questions that come in after this webinar. And I know that there are many questions that I didn't get to today. So I really appreciate everybody attending. I hope that what I was able to provide was useful for you today. And keep in touch. Stay tuned for the next one. I think it'll be in a couple of weeks' time.